Hello everyone. Today I'm going to start with new section which is section 156 of CRPC. We have earlier talked about section 154 and section 155 of CRPC. So this is in continuance with that section, with both those sections, as they all falls under a same chapter 12 of Code of Criminal Procedure. So in section 154 we have talked about the information relating to cognizable cases. In section 155 we have talked about the non-cognizable cases, whenever an information is received in such cases, and how the investigation will work in such cases. And in section 156 we are going to talk about the investigation in cognizable cases only. So section 156 clause 1 says that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable offence which a court having jurisdiction over the local area within the limits of such station would have power to inquire into or try under the provision of chapter 13. So this is a very simple section, that a police officer in charge of a police station may investigate such offences, actually only cognizable offences, without the order of a magistrate, as it would have a jurisdiction same as a court would have to try such cases. So basically there is a catch in this provision, which is investigate any cognizable case. In line 2 it is written investigate in any cognizable case. Investigate any cognizable case means the cognizable cases. First, let's clear the meaning of cognizable case here. Cognizable offences are enlisted in the first schedule of the code, so we can refer to all those offences to understand or to get a clear meaning of cognizable case here. And if any offense which is of a very serious nature and it has been done in a certain circumstances, so in but it is not enlisted in the first schedule of the code, then that particular case will not fall under the category of cognizable case, as it is not made cognizable by this particular act. Okay, so this was what cognizable offense meant in this particular provision. Now understand the phrase investigate any cognizable offense. So basically, if an investigation is being done by a police officer in a very correct way, like the investigation is going in a right direction and the offense is also of cognizable offense, so in that case the police officer is going in a right direction. But what if the case was not disclosing prima facie evidence that it is a case of a cognizable offense, and the police officer has taken step to start investigation in that case? So in that particular case, High Court has a power to quash such proceeding under section 482 of CRPC and under article 226 of Constitution. So this was all important in section 156 clause 1. Now let's jump on to section 156 clause 2, which says that no proceeding of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. So this is basically saying that if a police officer has initiated any investigation, then it will not be called in question at any stage merely on the ground that the proceeding is irregular. It will not vitiate the proceeding basically. So now come to section 156 clause 3, which says that any magistrate empowered under section 190 may order such an investigation as above mentioned. Yeah, so this is a very important clause here in all the above two clauses. In comparison with the above two clauses, this is a very small one liner clause, but yet this is very important. This empowers a magistrate to order an investigation to a police officer under section 190. So basically, the magistrate of first class and magistrate of second class, empowered by chief judicial magistrate, are may only take cognizance of cognizable offences, and they may take cognizance in cognizable offences upon receiving a complaint. First is upon receiving a complaint. Second is upon receiving a police report from a police officer or an investigating officer under section 173 of CRPC. And the third is upon receiving an information from any person other than a police officer that such offense has been committed. So in all these three cases, the magistrate may take cognizance of such offences and may order an investigation to police officer. First was this. Second is, this is written under section 190. You can refer directly to section 190 of CRPC, and you will find all these 3 points and the magistrates who are empowered under this section. Second important point here is that this section only empowers a magistrate at a pre-cognizance stage. If a magistrate has already taken cognizance under section 190 clause A or B or C, then the magistrate will no longer empowered under this section to order investigation to police officer. Secondly, if a magistrate thinks, this power can only be exercised if a magistrate thinks that a thorough investigation is needed in a case, and this can be done by a police officer, by an investigation done by a police officer only. Then only he will record his reasons before ordering such investigation to police officer. He will record his reasons, and then he will direct the police officer to start investigating such offences. And this was held in a case also. It was a case of Gujarat High Court. The case title is Suresh Kumar Gupta versus State of Gujarat. It is of 1997 case. So yeah, and there is a landmark judgment also in this section 156 clause 3. It is a very important and a landmark judgment. Sakiri Vasu versus State of UP. In this section, it was made mandatory that in this case it was held that a magistrate has a power to order investigation or to register a case and take all necessary steps for ensuring a proper investigation, including its monitoring. So these both two cases are very important here. This was all in this section 156. You may read commentaries if you have. It will give you a very sound knowledge of this section, as this section is a very deep section, especially clause 3 of this section 156. So you will find other cases also to read, and it's a very important section. So it would be good for you if you read more and more regarding this section. And if you don't have any commentary, you may simply refer to some judgments, and you can find it on Indian Kanun also. Like if you can simply write section 156 judgment, landmark judgments, or Supreme Court judgment, you will find you can find a lot of cases on some article, you can simply write down those case title, and then you can refer to Indian Qanun for to read those judgment. That will also give you very much knowledge. Sorry, very much knowledge about this section. So yeah, I hope this video has also helped you. So thank you.